Final form has been accepted.
Accepted.
You are for whom? Petitioner?
For the petitioner.
Why are you mentioning from this side?
Serial 99.
Counter has been filed.
Counter file.
No rejoinder is required.
Rejoinder file was studied. Serial 99. Harinandan Rajak. 732023.
99 तो कोई
You have to.
6 नंबर कोड से पहले दिखा
93 बोल रहे हैं ना
93
कौन सा कोड का? दूसरे कोड का मेंशन कर रहे हैं आप?
यही का जो लेकिन पहले का लिस्ट में दिखा गया था 6 नंबर कोड ये स्प्रिट किए हुए पहले से था बाद में नोटिफिकेशन हुआ सेल 93%।
पिछले से छुट्टी के बाद करिएगा, अब एक हफ्ता तो बचा है क्योंकि आप तो जल्दी से छोड़ेंगे नहीं पूरा दिन।
एक लाइन का
पता है
एक लाइन का कैसे
आपके लिए एक लाइन का होगा, मेरे लिए एक लाइन का
काउंटर पढ़ेंगे और कुछ नहीं पढ़ेंगे
तो ठीक है। इन टर्म्स ऑफ काउंटर एफिडेविट हम डिस्पोजल
ग्रेटफुल वो
उसके इसके अलावा कुछ
प्रमोशन का केस था जूनियर का हो गया है। हम लोग जब काउंटरेट फाइल किए कि जूनियर का हो गया, वो लोग कह रहे हैं कि क्रिमिनल केस में फाइनल फॉर्म हो गया इसलिए नहीं मिला। फाइनल फॉर्म हो गया तो
डिसाइड करना पड़ेगा ना कि फाइनल फॉर्म हो जाने के बाद मिलेगा कि नहीं मिलेगा।
फाइनल फॉर्म एक्सेप्टेड लॉर्डशिप और कोई ग्राउंड ही नहीं लिए लोग काउंटर होल्डर्स, दिस इज द ओनली ग्राउंड अंडर जूनियर आई एम वर्किंग लॉर्डशिप।
You wait for some time. You wait for some time.
Not today, Mr. Tomorrow, lordship. I will humbly praying lordship.
ये आप नेक्स्ट वीक मेंशन करिएगा।
Next week, lordship. Apply lordship.
Your Lordship, serial number 91 from the list, Your Lordship. It's a transfer matter, Your Lordship. And the transfer has been done by an incompetent authority. And on the last day, Your Lordship, the state was to file a counter affidavit and it has not been filed yet, Your Lordship. And
Who is for the other side? Call the other side. नहीं तो कल कर दीजिए, ऐसे तो आएंगे नहीं। कल कर दीजिए
91
My lord,
and go and inform the other side.
I am permitted to mention on daily call it 40 serial number 40. The exactly similar batch cases are listed on it is fixed on 12th April month. So it may also be tagged together. It is matter related to the first limited examination and all petition committed in those cases and this case also.
You are for the petitioner.
Yes, my petition.
At the request of the petition, counsel for the petitioner, post this case on 12th April.
12th या 15th है
ये 12 अप्रैल को
इन्होंने 12 तारीख बोला है तो 12 तारीख को लिस्ट रहेगा, जिस दिन रहे वी आर नॉट बॉदर्ड अबाउट।
उसको
आप लिख दीजिए उसमें 12 तारीख, पुट इट इन योर मेंशंस लिख।
आइटम 1 में सप्लीमेंट्री लिस्ट में लिख दीजिए
mention से
My humble prayer for few cases in the matter to be passed over because a partner matter started in court saying my senior was here itself. Subject to my outstandings.
Come at 1 o'clock.
1 o'clock.
Item Q, WPS 904 of 2023.
Yes, please.
in this case
may only print for passport. List of dates बन गया है print out नहीं। Only one case, just one.
Okay, one case.
One case.
One case will be passed.
Only one case.
Only one case it will be passed over.
हाँ.
Item for press filing item 3, WPS 3578 of 2023.
WPS number 3578 of 23. Learned counsel for the petitioner. Your name, please. Shailesh Kumar Singh. Under instructions of Mr. Rahul Kumar. Advocate on record submits that the grievance of the petitioner has been redressed and therefore he does not want to press the present writ petition. Learned counsel for the and seeks permission to withdraw the same. Learned counsel for the respondents has no objection to the prayer for withdrawal. Accordingly, this writ petition is dismissed.
Sign कर दीजिए For question item 4, WPS 350 of 2023.
Reference of the order dated 7/12.
क्या हुआ एक केस के बाद जिनको कॉल करना था? Where is he? Left the court.
He just went out.
You don't need to. He just prayed for Passover for one case. So I passed over for one case. Advocate should be very careful in using words.
Your Lordship, in this matter, reference be made to order dated 7th December 2023. In this last time, respondent state of Jharkhand was given last opportunity to file the supplementary counter affidavit. That said supplementary.
Yes, have you filed it?
I'm for state of Bihar.
You have filed it? They have filed it?
No, state of Jharkhand has not filed yet, and that is very much essential for fair education of the dispute. Because why it's essential, I shall place it. Your Lordship should have a look to the supplementary affidavit which was filed by me on 27/9/2023.
Yes.
Page number 7 of it. Your Lordship, this is actually a matter of the service lien. And if your Lordship should have a reference to the second para, I shall just read the second para. विदित हो कि आप जन संसाधन विभाग बिहार पटना में सेवा देने से पूर्व झारखंड सरकार के अधीन पथ निर्माण विभाग में सेवारत थे। वर्तमान में आप ग्रहणाधिकार लियन का उपयोग कर पुनः झारखंड सरकार में आप अपनी सेवा देना चाहते हैं। इस संबंध में निर्णय हेतु निम्नलिखित अभिलेखों की आवश्यकता है। 6 documents were required, and right from page number 8, just the next page, to page number 40 are the all documents which were required by the which were demanded from the petitioner, and the petitioner has supplied all those documents. Now, the next para says that after these documents are received in the office, the concerned department of road construction shall take a final decision. And now all the documents the petitioner has supplied. Now it's for the state of Jharkhand to take a final decision on the claim of the petitioner, either to allow my
They will
claim.
take a decision. I'll just fix a date. Simple.
एक टाइम फ्रेम कर दिया जाए.
सब चीज का टाइम फ्रेम होता है यहाँ पर. बिना टाइम टेबल के ये कोर्ट नहीं चलता.
But whether the service of the petitioner has been confirmed in Bihar or not, we don't know.
He was asked to furnish certain documents.
Yes,
And he says that he is in possession of all the documents, he has annexed it, and he says that he has already filed it. You take a decision.
My lord, I have received instruction, my lord, that he want to continue in the state of Bihar.
Yes.
We will be filing.
उनका इंस्ट्रक्शन आपके पास कहाँ से आएगा?
हमको स्टेटमेंट ऑफ फैक्ट है उसी से.
Your Ladyship,
So much.
You see, during the pendency of this writ petition, a letter was issued to him, and he was asked to submit certain documents. According to him, he has already submitted those documents.
page number 8 to page number.
Page
40.
number 8, and now the final decision has to be taken. This has to be taken by our Sachiv Prabandhan. Who is that? Respond number? Who is that respondent?
Your Lordship, that would be the respondent number 2, Secretary, Road Construction Department.
Our Sachiv.
Our Sachiv means
Under
additional
Secretary.
secretary.
Okay.
This is page number 7 is the letter given by State of Bihar to me.
Okay.
And now, after these documents were submitted by me, these documents were to be forwarded to State of Jharkhand, and now the State of Jharkhand is the competent authority to take a decision.
So from where do I get that it has been forwarded to State of Jharkhand?
ये उसके next जो last point 6 के बाद जो पैरा है उसको हम पढ़ देते हैं.
ठीक है.
उपरोक्त अभिलेखों की मांग विभागीय पत्रांक स्वयं दिनांक कितना द्वारा आपसे की गई, लेकिन उक्त वांछित कागजात आपके द्वारा कार्यालय को उपलब्ध नहीं कराने के जाने के कारण मामले में विभागीय स्तर से निर्णय लेने में कठिनाई हो रही है. इस क्रम में आपके द्वारा WPA
You see, so ultimately you have responded to this letter.
जी.
right? In response to this letter, you have submitted the documents. Now, this authority of the state of Bihar will do the needful, and whatever he has to do, that much direction we can give.
और ये प्रसंग में भी देखा जाए झारखंड सरकार के लेटर पर
That's
ये
right.
बिहार
After
सरकार ने
taking those documents, he will do the needful and forward it to the state of Jharkhand, and then necessary steps will be taken only thereafter. This is your grievance?
जी
Right. Who is this respondent?
वो
NHS 7,
respondent हैं,
state
हम
of
बता
Bihar.
दें। Respondent A, the Under Secretary Water Resource Department Government of
ठीक है मिस्टर विनीत,
Yes, ma'am.
that should be sufficient. अपना परसू करना है करेंगे, नहीं करना है नहीं करेंगे. We are not concerned with that. Okay? लिखिए. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the writ petition was filed on 21/2023, and during the pendency of this writ petition, a letter was issued to the petitioner dated 5/9/2023, issued by the respondent number 8, asking the petitioner to submit certain documents so that appropriate steps could be taken by forwarding. Appropriate steps could be taken and the matter could be forwarded to the concerned authority of the state of Jharkhand for necessary orders. Right, Mr. Counsel? Right. The learned counsel submits that in response to the letter dated 5/9/2023 annexed with the supplementary affidavit, the petitioner has duly submitted the required documents on 11/9/2023, but the petitioner has not been intimated with any further communication. Is there any further communication pursuant thereto?
उसके बाद
Uh,
this 5/9/23 वाला last communication
any further communication. He submits that appropriate order be passed so that the respondent number 8 may do the needful and ultimately the grievance of the petitioner is redressed. The learned counsel, you are for the state? आपके पास आएगा तो आप कर लेंगे ना needful. The learned counsel for the state of Bihar has also submitted that if no steps have been taken pursuant to letter dated 5/9/2023 and the response of the petitioner dated 5/9/2023, appropriate 11/9/2023, appropriate direction can be issued. The learned counsel for the state of Jharkhand has submitted that the moment the communication is received from the state of Bihar, appropriate order will be passed based on materials available. Right? After hearing the learned counsel for the parties and considering the nature of relief sought for by the petitioner, this court finds that no adverse order has been passed in connection with the claim of the petitioner as made in the writ petition. It further appears that during the pendency of this case, a communication has been received by the petitioner dated 5/9/2023 from the respondent number 8, in which a reference of the present writ petition has also been mentioned, and the petitioner has been asked to submit certain documents mentioned therein so that appropriate order/direction be issued for forwarding the matter to the in connection with forwarding the matter to the authority in the state of Jharkhand.
respondent number 2
That is respondent number 2. It further appears from supplementary affidavit that the petitioner has responded to the letter dated 5/9/2023 by letter dated 11/9/2023 enclosing the documents. But as of now, the grievance of the petitioner is that no final order has been passed and therefore the petitioner is suffering. That's right. In the aforesaid facts and circumstances, this writ petition is disposed of, enabling the petitioner to approach the respondent number 8 with the records of this case and a copy of this order and also a representation.
लीडरशिप एक चीज हम इस पे ऐड करना चाहेंगे ये जो पॉइंट नंबर 1 था उस कम्युनिकेशन का, देखिए उसमें त्याग पत्र से संबंधित आवेदन लिखा हुआ है।
जो
अब
है
टेक्निकल रेजिग्नेशन भी अपना दे दी। अब 8 महीना हम नहीं, मेरा बस सबमिशन में
नो नहीं, इतना दूर सबमिशन नहीं हो सकता है. फर्स्ट get your position secured and then fight for whatever relief you want further, isn't it?
ये तो अनसिक्योर
हाँ.
हमको बना दिया ऐसा
Just a
लेटर लेके।
To approach the respondent number 8 along with a representation and a copy of the writ records within a period of 15 days from today.
1 week
1 week तक order कभी upload नहीं होगा. Within a period of 15 days from today, upon filing of such representation, the respondent number 8 is directed to do the needful, and if any communication is required to be made, directed to do the needful and pass appropriate order, and if any communication is required to be made to the respondent number 2 pursuant to the letter dated 5/9/2023 and the documents submitted by the petitioner, the needful be done within a period of 1 month from the date of representation. Thereafter, the respondent number 2 is directed to take up the matter and do the needful within a period of 1 month from the date of receipt of the communication from respondent number 8. The respondent number 8 as well as respondent number 2 are directed to pass a reasoned order in connection with the claim/grievance of the petitioner, and a copy of the same is also directed to be forwarded to the petitioner through speed post at the address to be provided in the representation itself. It is for the concerned respondents to pass appropriate orders and as per the applicable circular guidelines, etc. This court has not entered into the merit or otherwise of the claim of the petitioner.
One thing, under secretary जो secretary को कर दिया है WRTP
Under secretary/secretary का.
क्योंकि लिखा हुआ निर्देशानुसार secretary action
secretary/under secretary. पूरा रिकॉर्ड लेके चले जाइए.
Passover case item 2, WPS 904 of 2023.
In this case,
ये नीचे इस ऑर्डर को पेंडिंग मत रखिए. ठीक है, ऐसे करा लीजिए. Yes.
in this case, only
What is the relief you are seeking?
the relief earlier, it is the second round of litigation. In the first round, death cum retirer benefit and the compassionate appointment was sought for. Honorable Court directed them to consider my case in 2022, and after that, they have already given me the entire death cum retirer benefit.
Where is the last order?
Last order, it is annexure.
Okay, so far as compassionate appointment is concerned, that has been denied.
Denied.
Okay.
That is annexure 6, page number 68. 16/12/2022, and here I will that after 19 years, and it could be only possible this honorable court order that they have given me the death cum retirer benefit. Okay. So far as compassion,
You are the
I am the wife of it,
wife of the deceased.
and so far as
What is the date of death?
death of death, that is a civil death matter.
What is the date of death? Date from which he was not
Yes,
traceable.
I have given just list of this.
Was missing on 16/4/2004. Okay. Then Asana was launched.
Immediately Sana was lost.
Okay. Then
Thereafter, the matter was kept pending. I was approaching to the pillar 4 because वो grade 4 का था. It was a sweeper just class 4 employee, and so far as the mental condition of his wife is concerned, she was approaching to the respondent continuously, and subsequently in 2015 she had also written approach to the Honorable Court, Registrar General, that is also an annexure, and from here onwards, mean that they have directed to consider the approach to the competent authority. Okay. Subsequently, in 2018, she was compelled to file a civil suit for the missing of her husband in 2018. In date 1/4/2020.
After expiry of how many years did you file this? 2018.
2014 years old.
After 14 years. You are entitled to file it after 7 years, isn't it?
After 7 years. After 7.
So you took 14 years to file it.
7 years. And now in 2018 we filed a suit there, and subsequently on 7/2/2020 the decree was passed, in which the debt was the decree for the civil debt for all the purposes since 28/5/2000. The decree is
How is it possible?
Yes.
I've seen it. I've seen the decree. First, just tell us.
Hold on.
You will be declared dead from the date you were missing.
Yes.
All right.
Yes.
So in you forget it. We will not enter into the decree.
Yes.
In 2020, he was declared dead with effect from 16/4/2004.
हाँ, ये इसी में डिग्री में ये लिखा है.
In the meantime, he was also dismissed from service.
हाँ, in 2010, when I filed the writ petition, and in a writ petition, when the direction was given, when they rejected my claim, at that point of time, they have specifically mentioned that on 19/5/2010, I was dismissed from service.
Where is that?
That is annexure, kindly your lordship, which is under challenge.
No. In the earlier writ petition, was it disclosed that the employee was dismissed?
No, this particular fact was not known to the petitioner as well as the
order of dismissal was not known.
Not. It was not known. It was not communicated. Nowhere notices was issued. It is admitted fact. Nowhere. Only this particular fact could be known to the petitioner only on this after the passing of this impugned order.
From where do I get this?
7.
From where do I get this? That you had no knowledge about the dismissal order
I
passed?
specifically mentioned.
Where is it?
In paragraph.
Which paragraph?
Earlier. Man. It is 12 onwards, 22.
Give me a specific paragraph.
Yes. It is further stated the petitioner claim was basically rejected on the original. Yeah. That the order dated 19/5/2000 is absolutely illegal and arbitrary. Para 24 euro. It may be seen.
Yes.
That the order dated 19/5/2010 is absolutely illegal and arbitrary, in which the petitioner was missing since 16/4/2004, and also mentioned that a sana was registered against the missing of the Ramesh Mehta by his brother, and despite of this fact, without giving any notice to the family members of the Ramesh Mehta, now given any assistance, no given any petitioner, simply dismissed the petitioner husband from service. That the concerned respondent could not appreciate or applied in this case, and that as per all the benefits here that concerned the Ramesh Mehta is missing is not. Since then, petitioner is trying to get the benefit
You
of
have not stated anything.
pension
You have annexed the order of
since
dismissal
then-
also. You have annexed the order of dismissal also. From where did you get this?
this particular fact could be given. इन्होंने हमको communicate किया.
आपने ये annexure 8. From where did you get this?
हमको दिया गया.
कब दिया?
इन्होंने दिया.
When?
ये दिया है.
Who gave you this?
हमको दिया गया. ये दिया गया है 1/2/2023 को.
कहाँ लिखे?
नीचे इसमें एनेक्सर 7 लिखा गया, एनेक्सर 7 पेज नंबर 70 नीचे दिया गया। एनेक्सर 7 पेज नंबर 70 वो हमको कॉपी दिए गए, कॉपी 2 ऑर्डर जब पास किए तो हमको कम्युनिकेट कर दिए। ये हमको किए हैं 1/2/2023।
No, I just want to know. This is the ground. This Annexure 8 is not an enclosure of Annexure 7.
एनेक्सर नहीं, एनेक्सर 7 में ही दिया है हमको, कॉपी 2 दिया है।
Annexure 7 में Annexure 8 is not an enclosure.
एनेक्सर 7 एंड एनेक्सर 8 बोथ हम लोग को दिया गया।
कहाँ से बोल?
नहीं, ये कॉपी है, इसका कॉपी है इसमें। ये हमको उसी समय पता है।
Annexure 7 का enclosure Annexure 8 नहीं है।
यही कम्युनिकेट हुआ है, ये जो कम्युनिकेट हुआ है,
देखिए
ये
जो
इसमें
चीज
दिया हुआ है, हर हस्बैंड रमेश मेहता एक्सीपर हैज बीन डिसमिस्ड फ्रॉम सर्विस बाय पीडीजी ऑर्डर नंबर
That's right.
इतना इतना 195।
That's right.
ये कॉपी हम।
No, it is not an enclosure to Annexure 7.
But so far as my case is concerned, that no communication has been made to the petitioner. This is the case of the petitioner, that no communication has been made to the petitioner before this order. They can also, even in their document, they can't show that any communication, whatever the communication, because I have been approaching to the concerned respondent since then, but no communication has been made. So far as even then, there is also a judgment of the Honorable Court. If once the civil debt is declared that this particular order is arbitrary, illegal, absolutely having no sense, उसमें इस Honorable Court का भी order है और वो up to the Supreme Court तक वो है, जो इस point पे भी जजमेंट है, इस पॉइंट पे भी हुजूर का जो क्वेरी है इसमें भी है जजमेंट कि वंस द डेट हैज बीन डिक्लेयर्ड।
And what was your age at the time of death of your father?
24।
Who is claiming compassionate upon
Wife.
Wife. So
Now
what
she-
would have been her age at the time of death of
She
your?
is now 44 years।
What was her age?
20, around 20।
20 years ही हुआ है क्या अभी तक?
अभी 20 साल।
94 to
नहीं, उनका डेथ हुआ 2004 में
2000.
और अभी 2024 हो गया, तो उस समय उनका जो डेथ है वो 44 के आसपास, 44-45 का, उस समय 20 साल में, और उसका जो शादी हुआ है वो 97 में मैरिज हुआ करके।
What was your when did you file your first application for compassionate appointment?
ये since then I have been filing, ये हमको तो कुछ भी नहीं, डेथ कम रिटायरमेंट बेनिफिट्स इमीडिएटली आफ्टर द पासिंग ऑफ दिस ऑर्डर, ये सिविल डेथ के बाद हम they are considering my case after that. Otherwise they were taking me lightly. They have not given, they were not considering, they have not communicating anything to me, nothing, and only that could be possible only after the passing of civil death they are taking me serious. And we are very deeply obliged that after 20 years entire death cum retirement benefit could be paid to me despite of the gross violation of one circular of this state government कि लापता व्यक्ति का यदि 1 साल तक यदि सनहा हो गया या FIR हो गया है और यदि पता नहीं चलता है तो he should be deemed as a civil death, और उसका जो डेथ कम रिटायर्ड बेनिफिट्स है वो उनको दे देना चाहिए। ये हमने लगाया हुआ भी डिस्पाइट ऑफ दैट। तो मेरा इसमें जो ये है सबमिशन है, मे आई काइंडली उनका जो रिक्वायर्ड, मेरा 2 कंडीशन में उन्होंने डिसमिस किया। पहला जो इनका जो कंटेंशियस इशू है कि हम मैट्रिक नहीं, दैट इज ऑल, और दे आर कंसिडरिंग द लॉ ऑफ 2018। My case is that a law which was already applicable as on date of death, means considering
That is 28/5/2004.
हाँ उनका जो डेथ का है वो 16/4/2004
Sorry, हाँ 16/4.
16/4 उस समय का जो लॉ है इट विल बी एप्लीकेबल इन माय केस माय फर्स्ट सबमिशन सेकंड सबमिशन है एज ऑन डेट जो उनका एजुकेशनल क्वालिफिकेशन था वो मेरे पे एप्लीकेबल फॉर दिस पर्पस द रूल्स ऑफ 1998 विल बी वेरी वेरी क्रूशियल हियर
What is the rule of 1998?
उसमें रिजॉइंडर में
Does it give any time frame for filing an application for compassionate appointment?
तो yes
It does, right?
Yeah,
You can't
yeah.
have it both ways, no?
yes
On the so far as cutoff date is concerned, you will take it as 16/4/2004, and you will say that application of 1998 rules will be there, and at the same time you will say so far as qualification is concerned,
as per rules it will be applied so far as the missing person is concerned. Unfortunately, on last occasion your lordship also enlightened your lordship profoundly में और उसी में हम लोग जजमेंट ढूंढे भी हैं कि जो सिविल डेथ है इट कोई सर्कुलर नहीं है दे आर सिटिंग दे आर साइलेंट अबाउट इट कि कब इनका कंसिडरेशन होगा कब क्या होगा कोई चीज का कंसिडरेशन नहीं एंड सो फार एज द पिटिशनर इज कंसर्न शी हैज बीन ट्राइंग शी हैज बीन अप्रोचिंग ये नहीं है कि बैठे हैं उनको तो शी इज सफरिंग since 19 years 20 years she has been suffering continuously suffering उसमें एक बच्चे का भी डेथ हो गया आई विल नेवर टेक दिस पार्ट उसमें इन द मीन टाइम कि उसका भी जो है considering उसका जो financial hardship she has been suffering subsequently only the last resort she could avail that is the suit in thereafter they paid me my entire death cum retirement benefit after 19 years of death and so far as the law is concerned section 10 ये बताता है कि एजुकेशनल क्वालिफिकेशन क्या था उस समय का जो एजुकेशनल क्वालिफिकेशन था कि एजुकेशनल क्वालिफिकेशन आई हैव आल्सो गिवन इन माय एनेक्चर इट मे बी रिजॉइंडर में दिया तो केवल एक देख लिया गया I have also specifically written down in my
where is it?
Paragraph
1998.
हाँ paragraph 6 में हम specifically लिख दिए paragraph 6 इसमें भी
You just refer to the circular,
sir
the compassionate appointment.
हाँ ये है 10 में देखा था ये पेज नंबर 16
Page number?
16
Where is that?
Page number
16.
19.
19.
Qualification for recruitment of class 4 staff.
No, I am not on that. Where is the provision for compassionate appointment?
हाँ, compassionate appointment. वो दो compassionate appointment का रहा है सर्कुलर में एक उस समय 2015 में आया है नया
Please show me the circular of compassionate
yes,
appointment.
kindly
Which according to you is applicable.
yes
Where is that?
annexure 2 page number 24
Of this rejoinder?
1991 law और इसके बाद सब्सिक्वेंटली आया है 2015
Annexure 2 is 99 page number?
पेज नंबर 24
Page number 24 is not annexure 2, main writ petition.
रिजॉइंडर
Rejoinder में आप continuous numbering नहीं करते हैं, वहाँ पे फिर से fresh numbering. Page number?
24
24. Okay, where is the...
ये
Yes.
सेवा काल में मृत सेवा सरकारी सेवकों के आश्रितों को वर्ग 3 एवं 4 पदों पर अनुकंपा के आधार पर नियुक्ति की प्रक्रिया निर्देशाल कहना है कि अब तक सेवा काल में किसी तरह की मृत्यु और सरकारी सेवा से इतना दे आर ओनली टॉकिंग अबाउट द डेड पर्सन, उसके आश्रित भी जांच कतिपय इतना अनुकंपा के व्यक्ति सरकारी सेवक के आश्रित को अनुमान्य होगा जिनकी मृत्यु सेवा काल में हुई है। अनुकंपा के आधार पर निम्न पत्र इतना आई एम कमिंग अंडर दिस, किसका आवेदन का समर्थन समय सीमा, आवेदन देने कोई समय सीमा नहीं होगी, लेकिन नियुक्ति हेतु अधिकतम उम्र सीमा की अर्हता की कड़ाई से पालन किया जाए। आवेदन पत्र का समर्पण और संकलन किए जाने वाले कागजात, आरक्षण नीति संबंधी निर्देश, नियुक्ति पत्र का निर्गत किया जाना, घोषणा पत्र, और एक बड़ा इंपॉर्टेंट चीज है जो 2015 का जो दे आर रिलाइंग अपॉन द 2015 को रिलाई अपॉन कर रहे हैं, उसमें भी बड़ा इंपॉर्टेंट चीज है हमारे पेपर में। 2015 में भी सी 2015 का 2015 पेज नंबर 30 वो है, दे आर रिलाइंग अपॉन 2000 जो अभी 2015 का पेज नंबर 30। उसमें शैक्षणिक योग्यता के बारे में बताया, ये पेज नंबर 31 लास्ट पैराग्राफ। शैक्षणिक योग्यता एवं अर्हता, आवेदक की शैक्षणिक योग्यता एवं अर्हता प्रस्तावित पद की नियुक्ति नियमावली में विहित प्रावधान के अनुसार हो। एंड सो फार द
पेज नंबर
31
30। 31 में कौन सा ऊपर?
नीचे एकदम लास्ट पर
शैक्षणिक योग्यता।
शैक्षणिक आवेदक की शैक्षणिक योग्यता एवं अर्हता प्रस्तावित पद की नियुक्ति नियमावली एवं विहित प्रावधान की अनुसार। और उसमें केवल इसमें जो कितना दिन तक हम दे सकते हैं, इसमें लिमिटेशन है 5 इयर्स का शायद लिमिटेशन।
और पुराने में कोई लिमिटेशन?
पुराने में कोई लिमिटेशन। ये 2000 एक और है इसमें जो लॉ है, जजमेंट, अभी रिसेंट जजमेंट है सुप्रीम कोर्ट, वो न्यू रूल्स first the important paragraph.
Yes. Prevailing on the date of applying for compassionate appointment are to be considered.
जब करने का है,
When did you apply? When did you apply?
I have already applied earlier in 2000 since 2004 to 10 I have already given.
Where is that application?
This is the missing one. I admit it was given. लेकिन जब हमारा civil debt, here the question is very very important. Once the concerned respondent is considering me as a dead on the date of this decree, then the rules which was prevailing at that point of time, it may be applicable in my case, and my application, once it is being then thereafter I am entitled to make an application. Otherwise अब उसमें होगा कि change.
We have seen that. We have seen the timeline.
Time. So once I am entitled, and the old law will be applicable in my case. So इसमें इसके बाद जो judgment है, so that maybe Canara Bank, your lordship.
So one is on the date of application, it has to be considered. So where is your application for compassionate appointment?
That is, they are
Where is
already,
it? Where is it?
after the passing of this, if this debt is considered.
Where is the application?
Annexure 5 series, page number 62 of the writ petition.
That's
after the passing of this order,
There is no mention of any previous application in this application also.
yeah.
Anyways,
Technically-
you finish your argument
Yes.
fast. Yes. This is
so-
one judgment you have placed. What other judgment are you
Other
placing?
judgment, Canara Bank.
Canara Bank.
Yes. Para number 12, it may be seen.
Para 12.
Request to some certain even copy.
You forget it. I am not convinced with you. Yes.
Para 12.
Yes.
The main question falling for the considered ये question, the same question कि the main इस केस में 2005 और 93 का rules था in question, and the para 17 में उनको ये किया
You are
हुआ.
not supposed to provide copies of the judgment to them.
What happened today? I'm really sorry, extremely sorry. इसमें क्या हुआ है कि एक कॉपी उन्होंने कम. That's why I also sought passover in this case. सारा चीज applying this.
आपके क्लाइंट लोग सुनते नहीं है क्या ऑनलाइन?
This is my.
वकील साहब क्या क्या कर रहे हैं?
This is my personal.
These are all recorded proceedings. You know, your client can log in any time and see what you have done in the courtroom, isn't it?
I personally seek.
So you have to say sorry to
Unconditional
your
apology.
client,
I seek
not to the court. We don't need any apology
I-
from your end.
Unconditional. That I
No,
couldn't.
I'm not seeking any apology. You should seek apology to your
I can.
client because you are representing your client, and much stakes are there, and we are listening to you. But you do not have any courtesy to extend the copies of the judgments which you are citing to the counsel for the other side.
Today is just missed. In a history manner. Para 17, applying this principle to the case in इसमें ये decide कर दिया गया. Para 17 is relevant here.
Yes, 90%.
Now the third judgment is of recent judgment 2022 SCC online. The relevant paragraph is
This is para 17. You have referred to para 12 and 17.
12 में issues था.
12 and 17, right?
Yes.
And so far as this 2022 volume 10 is concerned, you are referring to paragraph
Paragraph 10 and 11.
Okay.
10 and 11.
What else?
And the next judgment 2022 SCC online,
Yes, para
paragraph 18 and paragraph 12
and 18.
18.
Then
Yes. Now the important question
these
is
two judgments you are not relying.
judgment of these two judgments, these three judgments are very relevant here in our
These
case.
three judgments I have noted.
हाँ,
What
तीन-
about these two judgments?
Three judgment. These three judgments are of the civil debt. Civil debt. जो हमारा
All the three judgments are of civil debt.
civil debt of this honorable court and this honorable court as well as the supreme. Kindly, I may be permitted to place this.
All these three judgments are of civil debt.
Civil debt. These
Okay,
are
I'll
very
see that.
important.
I'll see that.
Just- Directly इसमें terminate your lordship have raised an issue about the 2010 judgment कि termination हो गया है 2010 में. This
We are
issue-
not raising any such
this-
issue.
this-
It was for them to, once they have given you the post-date benefit, there is no question of saying that
Yes.
he was, we do not know what
Yes.
stand they will
Yes.
take so far as that is concerned. We don't
So
bother
in
about
this case,
You are getting pension also?
family pension. I'm getting.
So you are not concerned about the dismissal of the petitioner
After
in
dismissal,
2010.
in 2010, your ladyship, after that also,
He is entitled for.
she is entitled for the other retirement benefits, and we are providing her all the retirement benefits, your ladyship.
So far
For
as
the GPF, group
in this
insurance,
judgment-
cashment, family pension, everything she is getting.
A person is entitled for pension, family pension,
Family pension, she is
after
getting.
dismissal also?
In this case, your
In
ladyship,
this case, but after dismissal also they are
if they
entitled.
are entitled, your
You know,
ladyship.
show me some law that even after dismissal from service on account of some misconduct, a person is entitled for pension. Because you have given them pension.
Yes, your ladyship.
Now you have given up your claim with regard of dismissal. You have not placed it on record in the earlier round of writ petition that this person stood dismissed on such and such date. There is no question of grant of compassionate appointment, right?
Yes.
And that particular order, the important thing is that what would be the date on which the civil debt takes its effect? Does it take its effect from the date on which the person is missing, or it takes its effect on expiry of 7 years, or it takes its effects from the date of declaration? There are 3 dates which could be possible. Isn't it? There are 3 dates which could be possible. In this decree, he has, from the date of missing, that decree has been passed. You are not a party in that proceedings. इतना तो सोचते भी नहीं है, बहस भी नहीं करते हैं, जानते भी नहीं. You are not a party. Are you a party? Are they a party? State is a party.
Earlier,
नहीं, in the suit
in the suit.
नहीं है ना? No party. You are not a party.
In general, in public.
Okay, complete.
No.
Please.
State is not.
No.
Very good.
May I say? The 2015 SCC online.
Yes, I have read it. Please don't repeat your
No,
arguments.
2015 SCC.
Yes, you have placed it, para
No.
number 12 and
नहीं
17.
उसमें नहीं फिर से ये इस हाईकोर्ट काउंटेबल हाईकोर्ट थैंक यू
15
तीन जजमेंट हम नहीं कर पाए
Pandey or Ram?
हाँ
Okay.
पांड्य
Yes.
एंड पैराग्राफ 7 नॉट वेरी इंपॉर्टेंट पैराग्राफ कट शॉर्ट एकदम स्पेसिफिक एकदम कट शॉर्ट
Yes, para numbers.
Having given envious thought to the statement of the parties in the canvas of the material fact noted herein above, it appears that the case of the petitioner is more or less similar to the case of Munidemi versus Central Coalfield Limited in WBS number such and such, in which petitioner husband also went missing on 5/6/2003 while working as a peace-rated worker at Kargil Washery under the respondent CCL, and in respect of the missing, a Sanha was also lost by her on 24/8/2003. The civil judge Junior Division Bermu at Temuga in title suit number 1 of 2011 instituted for declaration of civil debt of her husband decreed the said suit on contest after it was found that the employee had been missing for the last 7 years. In this said case also the employee had been terminated from service after the departmental inquiry initiated for unauthorized absence. The judgment rendered in the said case also relied upon the ratio laid down by this court in the case of Vijay Kumar Pradhan versus State of Jharkhand in WPS number such and such, while judgment dated 26/9/2013, where it was held that there is no difference between civil debt and natural. This is the important point. There is no difference between. The taking note of all such attendant fact, not only the order of termination of the employee was quashed, as the entire departmental proceeding did not have any meaning in the eye of law on the declaration of civil debt of such employee by the competent court. At the same time, it was also held that employee would be treated to be on the roll of the company on the date he went missing. It was also held that the claim for the compassionate appointment made by the said petitioner was also maintainable after declaration of the civil debt by the learned civil court. The employee would be treated to have died in harness on the date of his missing. the respondent were also directed in the said case to reconsider the claim for compassionate appointment, holding that the scheme is vogue under the respondent company would not override the judgment rendered by this court on the question that there is no difference between civil death and natural death. In the instant case, has also been found the departmental proceeding leading to the termination of the employee would not have no meaning in the eye of law once the declaration was made on the civil death of the employee by the competent court after institution of the suit 7 years from the date of meeting. Therefore, such ex parte process leading to the termination of the petitioner husband from service can't be sustained in the eye of law. Petitioner seems to have also made the application for the compassionate appointment within 1 year from the date of declaration of civil death by the learned civil court, which is well within the permissible period of 1.5 years reckoned for the purpose of making an application for compassionate appointment by the dependent
That's
of
got
the, this is this particular judgment was affirmed by the Supreme. It is I also given you
2021-16 SSC. Right, 384.
Yes.
Read the last paragraph.
2000.
Read the last paragraph, para 9.
9.
Read it, please.
ये हमारे अगेंस्ट
है ना अगेंस्ट?
जी जजमेंट में हमारे अगेंस्ट
तो फिर सुप्रीम कोर्ट से जो अपहोल्ड हुआ,
नहीं
it simply said
ये डिस्मिस सेट असाइड हुआ we are in
we allow the appeal.
Huh?
We allow the appeal. This order was set aside.
The order was set aside करके जो
And the purpose of it was also held that the purpose of compassionate appointment stands defeated with such long distance.
ये जो जजमेंट है ये that is against me.
Yes. Right?
Yes, sir. That is against me. And one more judgment of this, क्योंकि अभी इसमें करनी है तो एक और ऑनरेबल कोर्ट का जजमेंट था.
अब तो सुप्रीम कोर्ट का जजमेंट डायरेक्टली आपके अगेंस्ट में you have fairly cited it. You don't want to say anything more.
It may not be taken in mind. ये दोनों जजमेंट जो है
उनकी तरफ से हाँ हम आप इसीलिए बोलते हैं बिना पढ़े लिखे ना जजमेंट साइट मत किया करिए. हम खोज रहे थे इसी जजमेंट को आपने दे दिया. बहुत खुशी की बात.
तो my submission is twofold. The first is
देखिए आपको एक चीज बता दूं. इस कोर्ट में बहस करने में बहुत रिस्क है. Because these are all recorded proceedings. Right? And will remain recorded even if I die. You should be very careful in making submissions.
And also I try my level best to give a fair submission. I don't try to.
We appreciate your
whatever
endeavor in making submissions. But what I am telling you is that before citing any judgment,
yes,
read it full text. Because I read judgments full text.
Yes, I know. We have to assist. So far as the case, the petitioner case is concerned, that the petitioner.
I have understood. Don't repeat. Right? Yes.
In addition to this, the petitioner has not been deprived from her claims, as we have already mentioned that for the appointment and the compassionate ground, we are providing her the family pension with effect from 2004, Your Ladyship. In page 10, we have already mentioned.
So you have done. He is only concerned with compassionate appointment. What do you have to say with regard to compassionate appointment?
In regard to compassionate appointment, Your Ladyship, we are not sitting tight on this. The district court selection in my written submission also I have mentioned, or it has been considered before the head clerk civil court Dumka for the issue, and for the whole process we have rejected the compassionate appointment. Why? Because as per the compassionate ground is concerned, Your Ladyship, regarding her education qualification and date of birth, like matriculation certificate and birth certificate, in her application for appointment on compassionate ground, she has mentioned her education qualification as non-matric. and which is not concurrent with the provisions in the letter of 2015 of the Rajbhasha government of Jharkhand, Your Ladyship, and we have rejected on that ground. And in rejoinder, as he has mentioned in page 32, we can see that अनुकंपा के आधार पर नियुक्ति हेतु आवेदन किस प्रकार करें. Para 10, page 32 of rejoinder. अनुल्लंघन के विहित प्रपत्र में आवेदक अधोलिखित कागजात के साथ 2 प्रति में अपना आवेदन पत्र उसी कार्यालय में सरकारी सेवक की मृत्यु की तिथि से 5 वर्ष के अंदर समर्पित करेंगे जहां मृत सरकारी सेवक अंतिम रूप से कार्यरत रहे थे.
Page number 32, para number?
Serial 10, Your Ladyship. विभागीय परिपत्र संग्रह जो
हाँ 5 वर्ष के अंदर.
Yes, Your Ladyship.
That's right. So there was a time frame then also.
Time frame then also, Your Ladyship.
But at that point of time, the matriculation was not there.
Yes, Your Ladyship. After that, in the year which I've mentioned, according to 2015, Your Ladyship, because of the non-matric and date of birth, that's why we have not
That's
provided her the compassionate appointment.
Let me just frame the sequence. I will give the dictation at 4 o'clock. चार बजे आ जाएंगे आप?
From daily list for final disclosure, item 2, WPS 305 of 2023.
Petitioner. Nobody appears on behalf of the petitioner. Judge.
Madam, the last one is not directed to give the list of dates.
Petitioner is absent. What should be done? Otherwise, the pleadings are complete.
CC.
Yes, ma'am.
Also members. It's a very short matter, Your Lordship. Petitioner has paid for Your Ladyship. Petitioner has paid for washing of annexure to Your Lordship, that's right. An order has been passed to recover some amount from him after his superannuation without any proceeding as such. That was my case, Your Lordship. Without any show cause notice. Petitioner superannuated on 31/3/2022, Your Lordship, that I have given you para 9 में लिखे हैं. Now, why it has been recovered, Your Lordship? The reasoning given by the respondents in the counter affidavit, in my humble submission, cannot be taken accepted, Your Lordship. If Your Lordship turns to page 26 of a counter affidavit filed on behalf of the respondent number 2, 3 and 4. A copy has been served on me on 12/9/2023.
On what account it has been recovered?
They say an order of punishment was there, Your Lordship. And that they have annexed, Your Lordship, at page 29 Now this order is of 12/6/2007, Your Lordship. And the counter affidavit.
The impugned order is without show cause.
Yes.
Yes.
You make a recovery without show cause.
Lord, we have done it on the basis of the undertaking given by the petitioner.
No, but that also, for that also you have to issue them a show cause.
So cause is not.
Because they are saying that there was a punishment way back in 2006. Maybe that the effect of that punishment exists or it does not exist, and what is the reason? There is an order of recovery from
Recovery. Right?
that amount
has
was
been
never.
adjusted.
So therefore you need to give them a show cause, isn't it? Why should we decide in writ proceedings for the first time whether this amount should be deducted or it should not be deducted?
Lord, there was undertaking, Lord, I am relying on a judgment.
We understand that.
Yes.
Even if there is an undertaking, are you not supposed to give a small show cause that you intend to recover this amount from your post-retirement benefits? You can still rely upon that undertaking. We do not dispute that.
Ma'am.
But at least a show cause is required for passing any adverse order.
It
A
has
show
got
cause
severe
is
consequences. Yes.
That should be sufficient.
Yes, Your Lordship. If I am permitted to, Your Lordship, she will assist.
No problem. Who has passed the impugned order?
Lord, the annexure 2,
Has been
page
passed by?
16, it has been passed by the Assistant Registrar, Cooperative Society Rajasthan. Page 16.
We'll ask the registrar to do the needful.
Ma'am.
Right?
Here in this case, the respondent is the registrar is respondent number 3.
Respondent number 3 shall do the needful. Okay? The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has attained the age of superannuation on 31/3/2022, and by the impugned order as contained in Annexure 2, huge amount has been sought to be recovered to the tune of rupees 4,43,693.
One of the amount is 4,94,307.
Oh,
Bhukta
where is it?
Vasulniya Rasi.
Okay.
Yes.
The amount sought to be recovered is 4,94,307. The learned counsel for the petitioner submits that from the records of this case, it stands admitted that no show cause was issued to the petitioner prior to passing the adverse order of recovery, and therefore on this short point itself, the impugned order calls for interference. The learned counsel appearing on behalf of the respondents, on the other hand, while opposing the prayer, has submitted that though no show cause notice was issued, but the recovery was made on the basis of undertaking given by the petitioner himself. He has also submitted that there was an order of punishment imposed against the petitioner, which has been brought on record in the counter affidavit.
The writ petition has been done.
Even in the writ petition, this aspect of the matter has been disclosed. एक चीज और लिखिएगा petitioner के submission. The learned counsel for the petitioner has also submitted that has also referred to order dated 7th of February 2024 and has submitted that the petitioner also relies upon the judgment passed by the Honorable Supreme Court in the case of State of Punjab versus Rafiq Mashi, reported in bracket 2015 bracket close 4 SCC 334. अच्छा उनका बारे उनका submission में just add. The learned counsel submits that the judgment passed in the case of Rafiq Mashi Supra was subject matter of consideration subsequently in judgment passed by the Honorable Supreme Court in the case of High Court of Punjab and Haryana and others versus Jagdev Singh, reported in bracket 2016 bracket close 14 SCC 267, and has submitted that since the petitioner had given an undertaking with regard to recovery, the judgment passed in the case of Rafiq Mashi is not applicable. However, it is not in dispute that so far as the impugned order is concerned, no opportunity of hearing or no show cause was issued to the petitioner prior to passing of the said. After hearing the learned counsel for the parties and considering the nature of dispute involved in the present case, this court is of the considered view that even in cases that no order of recovery could have been passed as has been passed in the present case without giving an opportunity of hearing to the petitioner. Even if the recovery was pursuant to one or the other undertaking given by the petitioner. The petitioner may also have some submission with regard to the undertaking regarding recovery. Accordingly, on this short point, the impugned order as contained in Annexure 2 cannot be sustained in the eyes of law and is accordingly set aside so that an opportunity of hearing is granted to the petitioner for passing a fresh order in accordance with law. This, considering the nature of dispute involved in this case, this court is of the view that the required hearing is the hearing in the present case be given by respondent number 3. The petitioner is directed to appear before the respondent number 3 along with a copy of the writ records within a period of 15 days from today by filing a representation and also a copy of the entire writ records. Upon filing of such representation, the petitioner would be granted an opportunity of hearing. Petitioner or an authorized representative of the petitioner shall be granted an opportunity of hearing, and the respondent number 3 is directed to pass a reasoned order within a period of 1 month from the date of the representation. The reasoned order be communicated to the petitioner through speed post at the address to be provided by the petitioner. The recovery, if any, would be subject to the fresh order to be passed by respondent number 3. This written petition is accordingly disposed.
Item 3. My lord.
Call for it.
Item 3, WPS 7474 of 2023.
Are you appearing in this case?
No, my lord.
Who is appearing?
Matter related to dismissal from the service on ground of unauthorized absence, lordship. And major penalty has been imposed, that is termination. The absence of the petitioner from the service is beyond his control because his only son was suffering from complicated disease and ultimately he died. I have annexed the death certificate of his son and sermon is the death certificate. And due to that chronological disease,
What is the date of death?
15/10/2013.
What is the period of absence? And what is the cause of death?
Complicated disease.
What is complicated disease? I have never heard the name of this disease so far.
Death certificate.
What is the cause of death?
cause of डेथ लिखा हुआ है, इसमें नहीं लिखा हुआ होता है.
What is the period of absence? Did you inform them? Did you inform them? Did you inform the respondent the reason for absence?
A respondent's messenger went to my house, where he found that I was out for treatment of his son. They have sent some police person to my house. Where is he about? और उन लोग बुलाया भी कि आप चलिए, आपको कमांडेंट साहब बुला रहे हैं, लेकिन क्योंकि ये बेटे के ट्रीटमेंट में,
इसीलिए तो बेटे का ट्रीटमेंट का कागज कहाँ है?
ये पेपर है।
नहीं, वो सब कागज से हमको क्या मतलब है? आप अपने पॉकेट में रखे रहिए. Keep it in your pocket. We do not. इतना नेग्लिजेंट एडवोकेट हम तो देखे ही नहीं है.
डॉक्यूमेंट है, लेकिन चूंकि ये इशू नहीं था,
इशू नहीं था. आपका एब्सेंस बोल रहे हैं बेटे के इलाज में. कहाँ है डॉक्यूमेंट और कब से कब तक इलाज में आप बिजी थे? और व्हाट इज द पीरियड ऑफ एब्सेंस? व्हाट इज द पीरियड ऑफ एब्सेंस?
हाँ, ये 6 महीना था.
बताइए. गिव मी द एग्जैक्ट डेट.
एक थिंकिंग ऑर्डर में ये आया है, सब्सिडी से 17/12/2012 से 21/1/2013.
21 1
2012 and 22/21/2013.
You just see the charge sheet, page 40. Sorry, where is the charge sheet? In the counter affidavit, it has been.
Page 40.
Page 40 of the counter affidavit.
14 of,
Which 40 is the RO?
14 of my petition. उसमें भी लगा है ना? Counter में.
14 में कहाँ है? 14 में it is something else.
The actual period of absence, which as per us is from 2/10/12 till 8/9/13, that is 362 days.
2, 10, 12
to 8/9/13.
8, 9, 30.
362 days.
He has filed appeal also.
No, he is not preferred anyway.
Is it an appealable order?
Yes, yes.
You go and prefer appeal. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the respondents has submitted that the petitioner has an appropriate remedy of appeal, and therefore this writ petition may not be entertained. He has also submitted that disputed questions of facts are involved in this case, which cannot be adjudicated at the threshold.
My submission
In
is that major penalty has been imposed.
Yes, I will record the submission. Which cannot be adjudicated in writ jurisdiction. The learned counsel for the petitioner has, in response, the learned counsel for the petitioner has submitted that on account of absence from duty, major penalty of dismissal has been imposed, and in the intervening period, the petitioner was busy in attending to the medical requirements of his son, who ultimately expired on 5/10/2013. However, the medical documents in connection with the treatment of his son has not been placed on record. He submits that he is in possession, the petitioner is in possession of all the medical documents in connection with treatment of his son. Considering the nature of dispute involved in the present case,
since the termination order is of 28/9/13, so there will be a long gap. And apart from that, the petitioner, before initiating the appeal, he cannot
That will be an issue. Explanation I have given. It will be an
10
issue.
साल बाद क्यों आए हैं?
I was not intimated with the order, and I filed the application under
Just a moment.
RCI.
Just
I have stated in my
while going through the records of this case, it appears that the impugned order is dated 28/9/2013, which has been challenged before this court after expiry of 10 years. And upon a query from this court, the counsel for the petitioner has submitted that the order impugned in the present case was never served upon the petitioner, and therefore no appeal was filed. आप ज्वाइन भी नहीं किए होंगे ड्यूटी?
नहीं, हमें कहा गया कि आपका विचाराधीन है ऊपर के अधिकारी के पास, और वहाँ से ऑर्डर आएगा आपको ज्वाइन करा लेंगे। 10 साल तक यही कहते रहे, तो मैंने आरटीआई में एप्लीकेशन फाइल किया कि व्हाट इज पोजीशन ऑफ माय सर्विस, देन इंफॉर्मेशन वाज सप्लाइड टू मी इन आरटीआई दैट यू हैव टर्मिनेटेड, एंड व्हेन इंफॉर्मेशन सप्लाइड इन ईयर 2023, देन आई हैव फाइल्ड दिस एप्लीकेशन.
RTI application as per the petitioner is annexure 2, which was served upon him dated 24/10/18. Page 13 of the petition.
Under RTI,
He will file an application for condonation of delay. You pass the order. You have a time frame for filing an appeal?
Yes, that should be a relevant period, but here the case is totally different. He remained absent for a very long period. Initially, after joining, he remained. Earlier also there were 5 times proceeding against this particular petitioner, and he was let off with minor punishment.
अच्छा छोड़िए, चलिए बताइए, टाइम फ्रेम बताइए पहले, टाइम फ्रेम बताइए. Why is there so much of delay in filing this report?
no.
Where do you explain and how do you explain?
First of all, no information was given to me.
Where do you say?
I mean my petition.
Where is it?
Paragraph 10. Petitioner has submitted that after death of his son.
What is your date of joining the service? 12/11/2010.
Yes.
Okay. Then what happened?
Some of the petitioner fall in 2012.
Where have you mentioned?
I have stated the list of dates as well as in my government in petition also. Paragraph 10 में हम बोल रहे हैं that petitioner stated submit that after death of his son he approached the office of the respondent number 2, but no information had given to him about his service, and he was being kept in dark for 9 years by giving assurance that he may join in service when higher authority take a decision on the matter. Next, the petitioner stated submit that when he lost all the hopes upon the false assurance from the respondent, he made an application under RTI, get correct position of his service in the year 2018. Then information was supplied by the same office to him on 24/10/2018, which reveals the fact that petitioner has already been terminated from the service in the year 2013 itself. Your copy of the order of the dismissal and memo of charge also supplied to the petitioner, and then he came to know that he has been dismissed from the service.
That's it. That is all?
Next paragraph, that petitioner.
I've read it. I've read it. Where is the charge memo? He has not annexed a copy of the charge memo, isn't it?
Say page 40 of the copy.
For the learned counsel for the parties, this writ petition has been filed for the following relief. The memo of charge against the petitioner has been annexed along with the counter affidavit, which is dated 30/10/2012. Indicating that the petitioner has been absenting from duty from 2/10/2012 without any permission and without any intimation to the respondents, and the petitioner was earlier also subjected to departmental proceedings bearing number 01 of 2011, 07 of 2011, 02 of 2012 and 25 of 2012, but there was no improvement in the conduct of the petitioner. The petitioner was suspended with effect from 2/10/2012, and ultimately the petitioner was dismissed by impugned order dated 28/9/2013. The learned counsel for the petitioner, while challenging the impugned order, has submitted that the petitioner was engaged in connection with treatment of his son, who expired on 15/10/2013. A copy of the death certificate has been placed on record, and averments has been made in the writ petition that the son of the petitioner was suffering from complicated disease. The learned counsel further submits that on the point of delay in filing of the writ petition, the learned counsel has submitted that, has referred to paragraph 10 and submitted that after the death of his son, he approached the office of the respondent number 2, but no information was given to him about his service, and he was kept in dark for about 9 years, and by giving assurance that he may join in service when higher authority takes a decision on the matter. However, no supporting document or representation has been annexed in support of such statement. Further, the petitioner has referred to paragraph 11 to submit that the petitioner had made an application under right to information and was supplied the same on 24/10/2018, which revealed that the petitioner was already terminated from service in the year 2013 itself. And along with such application, such information, the petitioner was served with a copy of the order of dismissal and the charge memo. And thereafter, the petitioner has filed the present writ petition on 22/12/2023. The learned counsel, appearing on behalf of the respondents, has opposed the prayer of the petitioner and has submitted that and has referred to the counter affidavit. And has submitted that the petitioner was throughout aware of the disciplinary proceedings against him, and there is no cogent explanation for not approaching this court within a reasonable time. The learned counsel has also submitted that the filing of an application under right to information will not revive the cause of action, and otherwise also the document, as per the petitioner, the document and intimation, the document regarding his order of dismissal, etc., was provided way back in the year 2018, and the present petition has been filed after expiry of 5 years from the date the petitioner received the copy. The Learned Counsel has also submitted that the previous conduct of the petitioner was also not good, and therefore the present writ petition is fit to be dismissed. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the impugned order is dated 28/9/2013, which has been challenged by writ petition dated 28/12/2023. The records of the case indicate that the petitioner was well aware of the proceedings against him. It is further the past records of the petitioner, which has been mentioned in the charge memo, is also not in dispute.
Not
It
received
appears
by
that
the petitioner also. Charge memo was
Yes.
not received by
That's
him. There is no signature upon that.
yes. It further appears that the petitioner, from the records, it further appears that a blank statement has been made in paragraph 10 that after the death of his son, the petitioner was approaching the respondent number 2, but no information was given to him about his service, and the petitioner was kept dark for about 9 years. Further, no date, no representation, etc., has been filed in support of the statement made in paragraph 10. Such vague statement cannot explain the delay of 9 years as sought to be explained by the petitioner by paragraph 10. This court further finds that even if the best case of the petitioner is taken into consideration, the petitioner became aware of his order of dismissal and was also provided a copy of all the connected documents on 24/10/2018, and thereafter the petitioner has challenged the same after expiry of 5 years by affidavit date on 22/12/2013. The delay of 5 years is, the petitioner is completely silent in the writ petition so far as further delay after 2018 is concerned. Considering the totality of facts and circumstances of this case, this court is not inclined to interfere with the impugned order. The writ petition suffers from unexplained delay and laches. This petition is accordingly dismissed. I will cite 2 judgments which you have not cited. I put it here.
For orders, item 4 WPL 3912 of 2022.
What is it?
Notices were issued in the previous occasion.
Nobody is appearing. Notice was issued to whom?
Upon the applicant in the court documents.
We take appropriate steps. Nobody is appearing. क्या office note क्या?
I just could not ascertain whether it has been validly served or it has returned or not.
What is the order? Impugned order?
Impugned order means,
What is the nature of impugned order?
there were twofold prayer in the court below. First was that the dismissal of the employee
He has
was
been granted compassionate appointment.
no monetary compensation.
And has that been paid?
Milord, the only problem is that on the date on which the award was passed, the widow had already expired in the year 2017. Now we have taken a ground that for monetary compensation there were no application was never filed by them. Secondly, for monetary compensation, the condition precedent is that she should not attain the age of 60 years because it can go up to the age of 60 years or till she remarries or she dies unfortunately not in this case.
What I want to know from you is that how do we secure the appearance of the opposite party?
Paper publication.
You will file?
Yes, that can be.
WPL number 3912 of 2022. The learned counsel for the petitioner has referred to the office note and submits that in spite of issuance of notice, the undelivered registered cover has been received back. क्या नोट से आया है नॉट प्रेजेंट क्या है कुछ लिखते नहीं
Addressee left.
हाँ?
Addressee.
By with the note addressee left. The learned counsel submits that the petitioner is not aware about the present and correct address of the respondent, and therefore she prays for some time to file an appropriate petition for substituted service of notice. Let the needful be done by next week. Pose this case on next Wednesday under the same heading.
Item 5, WPL 5756 of 2022.
You have to file interlocutory application.
Yes.
Pankaj ji, she will file. Let the appropriate interlocutory application be filed by the next week. Amboli? Yes.
On the last occasion, we were asked if was the notice filed. We've done that, but the status report has not come in.
I appear for the respondent number.
Respondent number 2?
No.
What about respondent number 1?
My grievance is mainly from respondent number 1 only, my notes.
Why have you made therefore you have to ensure their appearance, no?
Yes, my notes.
Not received from respondent number 1. You take fresh steps. WPL number 5756 of 2022. Pursuant to the notice issued by this court, respondent number 2 has entered appearance. Counsel for the petitioner prays for and is granted time till next Monday to take fresh steps for service of notice upon respondent number 1, for which requisites under speed post as well as ordinary process be filed by Monday. Office to track speed post delivery. Post this case on 29th April, awaiting service report.
For fresh filing, item 6, WPL 1762 of 2022.
The petitioner challenged the award. Therefore, set aside the award, which the tribunal has decided the dispute that the employer and employee relationship exists between the management and Khas Kusunda Colliery and 319 General Mazdoor denying the employment. Fact is that the concerned workman is working as a general Mazdoor, they performing job of permanent nature of without any break and direct control and supervision of the said management. They are not the they are not the contractor worker, but direct employee.
You are representing whom?
My lord.
Your claim for regularization has been denied.
Denied. And award was passed, my lord. My lord, kindly see the page 35 of the award. My lord, the case received by the Ministry of Labour on, I am reading, my lord, page 35.
Yes, yes. What is the ground for challenge?
Challenge the, my lord, the concerned worker is the direct control of the management, my lord. And my lord is the direct employee of the management.
Where is the finding and where is your point?
My lord, the learned presenting officer has, my lord, denied only on the basis of affidavit filed by the, in this case, my lord, during trial, 3 persons has been examined on behalf of the workmen, and my lord, one is also, my lord, on behalf of the, my lord, respondent. And in this case, my lord, the Form B register has not been, my lord, considered. And
It was produced.
Produced, my lord.
Who produced it?
My lord, kindly see the representative union of the concerned workmen, my lord.
Where is the exhibit?
My lord, that is the exhibit, my lord. Exhibit that has mentioned, my lord.
Form B register was exhibited.
Coming up to para 15 and 16 of the award running page number 40. Means WW1 and WW2 are the concerned workmen.
On that basis.
WW1 says that they have been working in the colliery from 76 to 93. The workman is aged about 43 years in 13, and as per his affidavit, this means that he was a baby at the time of 1976. He was 2 years old and he is working from 73. WW2 is aged 40 years as on 5/8/11, and as per the affidavit filed by his condition is same. It is also admitted by WW2 that I have no paper to show that I was engaged by BCCL for work. It means they are not engaged by BCCL or not contract workers as per their own admission of witnesses and union. Pursuing the evidence of all witnesses, it appears that the persons are fake. Accordingly, the persons
How
are
many persons were involved? 139.
319 miles.
Who were paying them the wages?
319 workmen.
No,
Did they depose before the court?
No,
Why?
only 3 miles.
Why?
Because only 3 persons have been deposed.
So you are representing only 3 persons.
Only 3 persons have been during trial, my lord.
Whom are you representing? You are representing all 300,
19
all persons.
Miles.
They never deposed before the court.
Miles.
Then?
Then never depend, and in this case, my lord, the Form B register has not been, my lord, considered. And my lord, without this
So from where do you say this? Form B was not considered.
My lord, I have stated.
Exhibit number?
Exhibit WW3. I have stated, kindly see, my lord, I am reading, my lord, the deposition of WW3. I have annexed at page, my lord.
Where is your submission that Form B register was produced and not considered?
My lord.
WS are also not implied. The written statement.
Nothing is there.
WW page 25, my lord, I am reading, my lord.
Nothing is there.
No,
Your
no,
written.
consider.
Where is your written statement? Where is their written statement?
My lord, kindly see, my lord, page 25, my lord, WW3, paragraph 6, my lord. That from the register has been mentioned by the management, Xerox copy of register filed by the union. I involved in this dispute, name as I mentioned that treatment at the time of doing under job, the management has been provided by BCCL hospital, and in proof of the same Xerox copy of several letters have been filed in this case. That the management communicate the several official letters for regularization, and the same letter Xerox copy has been filed in this case by
Xerox
the
copy can be exhibited. Yes.
that has been identified as a letter. That has been. And in this case, we have to kindly consider all the 319 workers were off. The only 3 workmen have been deployed. WW1 is Dhirendra Kumar Jadhav, WW2 is the Harinder Ram, WW3 is the KDP Jadhav.
What about others?
Clearly proved.
What about others?
That has not been allowed.
Then, with respect to 1 and 2, it has been mentioned. What about others? They did not depose.
And apart from it, regularization can only be done if the person is on the rolls of the company. They are on the rolls. Here they say they are out of employment from 1994. So in year 2024, how can they be regularized when they are out from employment from 1994 itself? And if we take their age in 1973, they are 2 years old.
The reference is of 1994.
94. Yes.
The reference is of 1994.
Yes. And there is no finding that who had appointed them, who paid them the wages, who had the disciplinary control. So that
I have a clear category stated that the management is direct control of the melody.
The learned counsel for the parties are present. The learned counsel for the respondents has opposed the petition by submitting that the basic documents in support of the petition are not there. At this counsel for the petitioner prays for and is allowed 2 weeks' time to bring on record the relevant materials for the purposes of the present petition, which he seeks to rely upon to show if there is any perversity in the impugned amount. आप फाइल कर दीजिए. Let the supplementary affidavit be filed by April 3rd. Post this case under the heading for orders. नहीं फाइल करिएगा तो डिसमिस कर दीजिए. 3rd April. नहीं 3rd April तक आप फाइल करिए. 4th April को ऑर्डर्स में रखें.
Item 7.
Do you want to file any counter in the meantime? Let him first bring it on record.
Yes.
You get that sale judgment also.
Yes.
Otherwise, I would have decided it today itself, but that judgment is not there with me right away.
Item 7, WPL 2989 of 2022.
In this case, my lord, the petitioner is related to accepting in 11 of the writ application. Where under the petitioner is sought for release or still of food bank races and other benefit for the period 1989 and
Where is the impugned order?
accepting the annexure. I want to first to refer annexure 10, my lord.
Okay.
At page 75. That is the order passed under upon the petition filed under section 33C2, my lord. The workmen claimed in this LC this back wages and ways of idle
Page number 70.
75.
The workman claimed, yes. Any read it?
That is the judgment of
Read
the
it, please.
the workmen claimed in the LC the back wages and back wages and ways of idle period for which he was postponed, suspended, and now is claiming the amount. The might is demand to pay him anything, but the workman in his evidence is as follows. I was surface.
That's right. It is not a 33C2 petition. 33.
It is order. It is order passed in the
33C2.
Yes.
So this is not a. This is a disputed amount. It cannot be directed to be paid under 33.
And thereafter, my lord, the petitioner, I want to defer annexure 11, my lord, just after the next case.
Yes.
Order dated 22nd October 2020. I want to do that. This order, this is an order for on the petition filed by the learned lawyer of the applicant.
Rightly dismissed. Rightly dismissed. Review petition.
So my lord, what is the case, ma'am? If you want.
No, 33C2, the matter is very, very simple. The moment there is a dispute regarding your entitlement, 33C2 is not needed. You have to raise an industrial dispute for that.
No, not. It is the mistake. It is the but the case is very in the year 1989.
No, we are not concerned with the long story, right? You have got any judgment? Not got.
It is in the nature of an execution proceedings.
Yes.
The rights have to be crystallized.
WPL number 2989 of 2022. Heard Mr. A.K. Rashidi, learned counsel appearing on behalf of the petitioner. Heard Mr. Your name? Amit Kumar Sinha, learned counsel appearing on behalf of the respondents. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner had filed an application under section 33 within bracket 2 within bracket C within bracket 2 of the Industrial Disputes Act, which has been dismissed by the order dated 13/12/2016, and the learned court below, the learned court, the learned central government, central government labor court, industrial tribunal.
Come labor court.
The learned central government labor court number 2 Dhanbad has rejected the relief. By saying that the claim cannot be allowed as the petitioner did not raise any industrial dispute and is not entitled to anything. The learned counsel submits that a petition for review was also filed, which has been dismissed by the order dated 22/10/2020, and both the orders are under challenge. The learned counsel appearing on behalf of the respondents, on the other hand, while opposing the prayer, and has submitted that the proceeding under section 33 within bracket C within bracket 2 of the Industrial Disputes Act is essentially in the nature of execution proceedings, and there is no question of any adjudication, and the entire dispute, the amount is not an admitted amount, so as to and therefore the petition, that therefore the impugned orders do not call for any interference. After hearing the learned counsel for the parties, this court finds that the case of the petitioner was that he had filed a petition for payment of rupees 19.80 lakhs as full wages and other attendant benefit for the period from 18/8/1989 to 30/9/2000. And the same was contested by the respondents. And was ultimately dismissed by order dated 13/12/2016 as follows. Quote kar dijiyega. Annexure 10, page number 76. It's a short order. Upon perusal of the order dated 13/12/2016, it is apparent that the claim of the petitioner is a disputed claim and therefore the petition under section, and therefore this court is of the considered view that such relief could not have been granted to the petitioner in a proceeding under section 33C2 of Industrial Disputes Act, as the claim of the petitioner required adjudication. This court finds no illegality in the impugned order dated 13/12/2016. So far as the subsequent order dated 22/10/2020 is concerned, the same is an order dismissing the review petition as not maintainable. This court has gone through the order dated 22/10/2020 and does not find any illegality or perversity in the order. In the absence of any, in view of the aforesaid findings, there is no illegality and perversity in the impugned orders. Accordingly, this petition is hereby dismissed.
Item 8, WPS 3648 of 2023.
Yes, petition.
Earlier also the petitioner has approved this. Case is for
What?
the wrong fixation of pay scale.
Impugned order is there.
Yes. Lecture 5.
They have filed their counter.
They have filed and I have filed rejoinder also.
This requires a list of dates.
Yes.
The learned counsel for the parties are present. It is submitted that the pleadings in the present case is complete. Counsels to file short synopsis, list of dates, and the judgments which they seek to rely upon prior to next stage of hearing. By 6th of May, post this case on 7th of May, 2020. Admission. Fresh filing under the heading for admission.
Item 9, WPS final.
Final disclosure.
आप फाइल करिए ना, 4 डेट तो फाइल करने को ले लेंगे आप.
Item 9,
कर
WPS
दीजिए, आप मेंशन करेंगे, हम कर देंगे.
72 of 2023.
Lordship, on advertisement was flouted for appointment of constable. This petitioner applied in that advertisement, appeared in the written examination.
What is the date of advertisement?
The advertisement is dated. The page 13.
Yes, what happened? What is the ground of
Now,
rejection?
my candidature has been rejected only on the ground that I don't fulfill criteria as per the required height. Now, Annexure 5 is the document by which my candidature has been rejected. The very first page suggests
Page number.
Page 43.
43.
The very first page suggests that my height has been measured at 169 centimeters. And required was 170. Your Lordship, I would like to invite the petition to my supplementary affidavit.
Did you file your appeal?
But the advertisement suggests.
No, it is there in the impugned order itself. It is there in the impugned order itself.
Only one document I will show.
What document?
The record itself shows what they have done. Only that.
What is it?
The supplementary affidavit. Page number 8.
Yes.
Now, the same respondent had flouted as the advertisement for the same post in the year 2018. My height was measured by the same department as 170 centimeters. And subsequently in 2021 also, same post, same advertisement by the same respondent, they measured me there that 171.5 is my height. Now in
So your height
they
was,
say that 169.
No. Why didn't you file your appeal immediately? It could have been measured.
Your Lordship, I approached the respondent number 3 itself there and then.
When did you approach?
On the same day.
Where is that?
I have made my statement in para. Para 11.
No, where is your, when you approach means what? You have to approach by filing an appeal, no?
There is no appeal.
There is an appeal.
We have not filed any appeal to that aspect. That is there.
And this happened when?
This happened in 23 itself. 10/5/2023 is the date of the resolution.
In one case, I have held that your previous measurement will have no value. I have held in one case that previous measurement will have no value.
Yeah. Where is it? But
this will not so far as the present case is concerned, not so far as the measurement is concerned. The advertisement itself page 33. The physical standard test model was.
No, that is okay. His only contention is that his measurement was 169 centimeters. In the previous occasion, it was 170.
This one, page 35 fairly similar so far as the part is concerned.
35.
The candidate who are declared not qualified in physical standard, that is height and chest, may prefer an appeal on same day if they so desire to the appellate authority nominated for the center through presenting officer.
I'm not getting that. Page number 30.
Page 35, no?
There are double page numbering.
This is paragraph 11.5.5 of the notice.
5.5. Yes.
There is a provision of appeal on the same day itself. If at all he was agreed with respect to that part, he could have made the application so that it could have been verified second time. Only for that purpose, so far as the chest and height, the difference can be there. There is a provision of appeal. On the same day, it was required to be done. That has not been done with the petition.
I passed one order on this. In your case.
I'll verify also with the accountants.
I was relying on the document. The coordinate bench says that when there are two documents suggesting two different aspects with respect to physical measurement, there has to be a board to be constituted.
That is the provision given therein, that could have been availed by the petitioner in terms of 11.5.5 itself. He has not availed, now he is coming after such a long time. There is a provision, if there is a mistake to that part.
The post must have been filled by now.
So far as that part is concerned, I have to take instruction.
Please
at the moment, I cannot
instructions
say.
if they have been already filled.
Yes, madam.
There is no question of any
Yes,
fresh
madam, I
measurement.
take instruction.
Because others will have to be displaced.
Good. So far as these two specific issues are concerned, madam, so far as the height and chest is concerned, the difference already, if that is being found, madam, then it is good.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that on the previous occasion when the petitioner had participated in the selection process conducted by the respondents, the height of the petitioner was found to be 170 centimeter as on 16/8/2019.
And thereafter,
And subsequently in the present selection process, his height has been recorded as 169
in 2021,
centimeters.
171.5 level. There were, this is the third time I have applied. There were 3 measurements.
In one of the selection procedure, his height was measured as 171.5.
0.5.
The learned counsel for the respondents has referred to page 28 of the writ petition and submits that there is a clear-cut provision of appeal which was to be filed on the very same day, and the order of rejection of his candidature at Annexure 5 also indicates that he could have preferred an appeal on the very same day so that his height could be measured and re-verified. He has further submitted that having not availed the provision of appeal, the petitioner has filed the present writ petition after a long gap, and therefore the present writ petition may not be entertained. Counsel for the respondents is directed to seek instructions and file a counter affidavit clearly indicating and file a counter affidavit and further also indicate in the counter affidavit as to whether the post advertised have already been filled. It is made clear that if the post advertised have already been filled or there has been a subsequent recruitment process advertised, there is no question of grant of any relief to the petitioner.
I will file it within 3 weeks.
Let the affidavit be filed by 4th April. 4th April, post this case in the supplementary cause list on 9th of April. 2 situations, right? Then we will see. There is one judgment we have considered other high courts also.
No, that is the reason, my lord.
Wherein I have stated, I have held, I don't know whether it might be subject matter of appeal, that the previous parameters or previous measurement cannot be a reason for consideration of or rejection of candidature. There could be a reverse also. Height will
never decrease of a 22
So
year old
therefore,
child.
now
We do not know. There can be reverse also.
The medical studies suggest that 30 year is the bar.
That is why you have to file
can
your
differ,
appeal on.
But by 30 it can never, till 30 it can never reduce. And it is their document, it is not mine that I have approached any
that is
other
the reason, my lord,
hospital
for the
or
same
any
year,
authority
Then
for
under
my
such
measurement.
circumstances, a candidate who is coming, there should not be any fresh measurement of height. He should just produce a certificate of the
Yes,
last measurement,
previously
and
I
that
have
should be
measured
enough.
like this.
Isn't it?
Item 10, WPS 5452 of 2023.
आप देखिएगा हम किए हैं एक ऑर्डर, उसका पता भी करेंगे कि इसमें अपील हुआ है. It was being argued by आप थे respondent? I don't know. Somebody was there. Yes, please.
So I have 2-4 prayer. The petitioner is a retired professor from Vinoba Bhave University. Now he was given his EL for 300 days. He retired in 2021.
Counter filed?
No. And there is a recovery from my pension. They say that now I am entitled for 183 days instead of 300 days. I worked as a finance officer for 10 years. My service condition.
Counsel for the parties are present.
For respondent number 5, what is the grievance plus? I could not recollect from the file itself. Only one request plus Annexure 4 is the document issued by respondent number 5, Sidhu Kanu Murmu University.
File your counter.
No, I will say what is the whether he is proper party. I worked as a finance officer with Sidhu Kanu Murmu University for 5 years. Thereafter, I worked with finance officer at Innova University, where I then joined as. So even if he is not a necessary, he is a proper party to respond to that.
They are not claiming any relief against you, but maybe some fact is required from your end. The learned counsel for the parties are present. Let counter affidavits be filed in the present case by 10th of April, rejoinder by 24th April, post on 7th of May 2024. List of dates. Do you need list of dates here? Not required.
I will still give, madam, because my
list of dates and synopsis of argument be filed by 3rd of May.
And one thing I would indicate, the state has filed its affidavit, but it is of no use. They are not on the merits of the case. Okay. They say that it is university to respond.
That's it.
Recovery is on merits. Can I make submission that it may be...
Amount has been recovered.
From my pension, 25,000 is being recovered every month.
Please hold on. You will get back everything. They are not going to run away.
Item 11, WPS 5529 of 2023.
In this case, the prayer of the petition is to allow them to represent before the State Service Commission for document verification and consider their case for appointment of trained teachers, Your Worship, arising out of the advertisement number 21 of 2016.
No, I have already passed order. We cannot pass any order. You have to go to Supreme Court.
And this is done, yes, Your Lord. I am aware WPS 4936 of 2023 and ML of
it is covered by that. I will simply say that it is covered by that. If you want to go to Supreme Court, you can.
It's arising out of the same advertisement. Only the subjects are different and there is some different factual metrics. There is some different. There are two petitions.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. At the outset, the learned counsel for the respondents has submitted that the present case is squarely covered by a judgment passed by this court in WPS number
4936 of 23.
4936 of
2023.
2023. The counsel for the petitioner has gone through the state judgment and does not dispute that the point involved in this case is squarely covered by the state judgment. Accordingly, this petition is dismissed in terms of WPS number 4936 of 2023. What is happening in Supreme Court? Some of the candidates have won.
Yeah, some of them, but I am not aware.
There is a clear direction that no order is to be passed by.
Yes.
So if we ask you for further verification, then the time frame is also going to be flouted. So we can't do anything. Next.
Item 12, WPS 5548 of 2023.
Related to compassionate appointment, the limited demands of the petitioner remain allowed. They have issued a letter to petitioner that you come with certain documents. Annexure 7, if my lord will kindly see, page number 27. आपके द्वारा आवेदन पत्र को इस कार्यालय को प्राप्त हुआ इस संबंध में पूर्व में भी कागजात के साथ उपस्थित होने को कहा गया, लेकिन आज तक कार्यालय में कौन सा कागज है, क्या है, that is the
कागज बता दीजिए. You don't need a counter affidavit for this. What is the date of death?
6/2/2015. 6 फरवरी 2015. He was working as a khanic.
You are representing the learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel has referred to Annexure 7 of the writ petition to submit that a letter has been issued to the petitioner by indicating that earlier also petitioner was asked to submit certain documents, but the same has not been produced. However, the letter dated 12/5/2022 neither gives the detail of the earlier letters nor
The required documents.
the required nor the list of required documents have been mentioned. The learned counsel submits that the moment appropriate order may be passed so that the list of documents may be provided. The list of required documents may be provided so that the claim of the petitioner is ultimately considered by respondent number.
Respondent number 6.
Respondent number 6. Up Prabandhak. Assistant manager. Is it respondent number 7 who has issued this letter? Respondent number 7, assistant manager. है ना?
Three may be directed because it will be done from the head of
By the respondents. The learned counsel for the respondents has submitted that
three may be directed.
the petitioner may be directed to approach respondent number 3 for the needful. Right? After hearing the learned counsel for the parties and considering the document as contained in Annexure 7, which is dated 12/17.05.2022, this court finds that the letter, by the said letter, the petitioner has been asked to produce the documents by stating that in spite of earlier letters, the documents have not been produced. However, this communication does not refer to any earlier communication to the petitioner, nor does it give the list of the documents which is required to be produced by the petitioner. In such circumstances, the communication by the Annexure 7 appears to be vague, which appears to be a reason for not taking up the matter for the petitioner regarding his claim for compassionate appointment. The petitioner is directed to appear before the respondent number 3, who in turn would duly intimate the petitioner in connection with the required documents, and also the earlier communications which might have been issued to the petitioner, and thereafter consider the grievance of the petitioner in accordance with law. It is further made clear that if any decision with regard to claim of compassionate appointment has been taken in the meantime, no fresh steps or order need be passed. Yes, the needful will be done by the respondent number 3 within a period of 2 months from the date of filing of representation, along with a copy of the writ records and a copy of this.
Item 13, WPS 0548 of 2023.
The petitioner is a widow who has approached this court for considering her case for compassionate appointment and the release of all the.
What is the date of death?
2nd of January 2023.
2nd, 1,
2020.
2020. 23. When did you apply?
Whereas I had representing them because my case is that the husband of this petitioner was in Navy. He was working as on the post of mechanic in Navy. Whereas now what has happened, during his lifetime he has initiated one case for dissolution of marriage. That case was dismissed by the first court, that is the principal judge at Gumla. Now he had filed one first appeal. I was noticed and during the pendency of that
It was
case,
decreed?
not decreed.
Not decreed. Okay.
Not
So
decreed.
ultimately no
Ultimately,
divorce
I
was
retained my
granted.
position as a wife.
You consider whom, before whom have you filed?
बस
इसमें काउंटर नहीं हुआ अभी
Counter का क्या काम है? He is seeking compassionate
And-
appointment. You
and the-
consider it. If you are not,
नहीं रिलीज ऑफ वही है
तो वो भी आप consider कर लीजिए.
Because I was
है
also
ना?
being paid maintenance by them, they have stopped it.
There
Rightly, they
is
have stopped it.
who will
The commanding
consider?
officer.
Whom have you represented?
10,000 were being
The commanding officer, matlab the
Command respondent number?
respondent number. Respondent number 4.
4. Respondent number 4 in Kerala?
Yes, that was my last. The husband was posted because I'm also not clear about because the whereabouts of my husband were also not being shared by him. And if the respondent number 6, respondent number 6 is the unit which operates from they have a proper office at Mumbai, and I have made a representation to him also. Respondent number 6 is also a commanding officer. Commanding officer DPSC, the Naval Dockyard SBS. Because commanding officer is it is a fleet, it would be difficult to communicate it.
The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the husband of the petitioner expired on 2/1/2023, and thereafter the petitioner has been fighting for a post-death benefits / compassionate appointment. Representation to this effect has been made before the
Respondent number 6.
respondent number 4 and 6 both.
6 months.
Respondent number 6 as contained in Annexure 5 to this petition, dated, which was sent through post on 9/2/2023. But no decision has been taken so far. The learned counsel has also submitted that the petitioner was getting maintenance as she was in litigating terms with her husband, but prior to dissolution of marriage, prior to any final order in connection with dissolution of marriage, the husband of the petitioner had expired. After hearing the learned counsel for the respondents has submitted that no counter affidavit as such has been filed in the present case. After hearing the learned counsel for the parties and considering the nature of relief sought for in this writ petition, this court is of the considered view that no adverse order has been placed on record and the grievance of the petitioner can be considered by the respondent number 6 at the first instance. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 6 by filing a representation and a copy of the writ record along with a copy of this order. And upon filing of such representation, the respondent number 6 is directed to pass a reasoned order in connection with the grievance of the petitioner. You want some hearing? Mumbai
will be difficult for
them. They will take care.
They will take care. They will communicate
after
us.
Verifying the records. The reasoned order will be communicated to the petitioner through speed post at the address to be provided in the representation itself. This petition is accordingly supposed to.
Further case from supplementary list item 1, WPL 5260/2019.
Apart from citing these judgments, do you have anything to say? That the case could not have been decided on merits?
Yesterday I made my observation.
Yes, what is?
The case is, if your lordship sees the dispute which they had raised, lordship, that is annexure 1, page 20. That Santilal Maji had been working, Santilal Maji had been working as a permanent minor loader at such and such colliery and unrecognized service record. The concerned workman has been absenting in his duty due to his serious illness, and that was duly informed to the management. Then the management dismissed him from service by an order dated 18/1/2010 after conducting invalid irregular. The dismissal of the concerned workman is illegal, void of initial. Management dismissed an Adivasi workman alleged ground of absenteeism. Concerned workman died on February 16, 2000 due to poverty, denial of medical benefits. That after death, the concerned workman of the concerned dependent, namely such and such, represented the management dependent for employment, and management denied the same.
That's
so, also admittedly from date of dismissal till date of death, the said workman or the union never raised any dispute. So this I am submitting in the context of the judgment which I have given 2015 volume 15 SSC page 1. Lordship will see two
How
paragraphs.
does the union raise a dispute on account of a workman who has deceased?
Already died. That is one of the grounds. The workman was a member of a union during his lifetime. After his death, he does not. But even if we go to that extent that on the behalf of the dependents also in certain cases, if we permit that, they can raise it. Also, they did not raise the dispute immediately after the dismissal of the workman for 6 years. The Honorable Supreme Court says here, in 2015 volume 15 SSC page 1. I have mentioned relevant paragraphs are here, paragraph 12 and 42.2 and 42.3. Also, I am reading out paragraph 42.2 and 42.3. There the Honorable Supreme Court does not say that belated cases, then you should dismiss it in all cases. So if there is an explanation, I read it only to show that there is no explanation. But you have page 23, paragraph 42.2. May I read out? Dispute or difference arises when a party makes a demand and other party rejects the same. It is held that
page number, sorry?
Page 23 of this judgment.
Page number 23, paragraph number 42.2. Yes.
Dispute or differences arises when one party makes a demand and other party rejects the same. It is held by this court in number of cases that before raising an industrial dispute, making of a demand is necessary precondition. In such a scenario, if the services of the workman are terminated and he does not make a demand, he never made a demand in his lifetime, and or raise a issue alleging wrongful termination immediately thereafter or within reasonable time, and raises the same after considerable lapse of period, whether it can be said that the industrial dispute still exists. Since there is no period of limitation, it gives right up to the workman to raise a dispute even belatedly. However, if the dispute is raised after a long period, it has to be seen as to whether the dispute still exists. Thus, notwithstanding the fact that law of limitation does not apply, it is to be shown by the workman that there was a dispute in presentee. For this purpose, he has to demonstrate that even if considerable period has elapsed and there are latches and delays, such delay has not resulted into industrial dispute cease to exist. Therefore, if the workman is able to give satisfactory explanation for such latches and delay and demonstrate that circumstances close to the issue is still alive, delay would not come in the way because the reason of law of limitation has not been. On the other hand, if because of delay dispute no longer remains alive, it is to be treated as dead and then there is non-existent. Here in this case, the workman died during his lifetime for 6 years, he never raised any dispute. Now, Your Lordship, the dispute arose only when the dependent sought for employment. If a person has been dismissed, the dependent cannot seek an employment. Now, Your Lordship, when that employment has been negated, that you cannot because your father was not in service, Lordship, then the union in 2016 makes a complaint before the Assistant Labour Commissioner that no, that termination may be held illegal so that the employment can be given. So that is the still dispute.
In response, do you want to say? Yes.
Well, all these are matters of evidence. My Lord, kindly have a look to the paragraph 11 and 13 of the TELCO Convent. My Lord, central government can form an opinion whether dispute exists or is apprehended. That much only. Central government cannot adjudicate the dispute. Now, kindly see the refusal order.
Para number 10 and 11. Where is that judgment? Telco convoy?
Yes.
Yes, Telco convoy. Para number 10 and 11.
11 and 13.
11 and 13.
Paragraph 11, Telco. May I read it?
Yes.
It is true that in considering the question of making a reference under section 10(1), the government is entitled to form an opinion. Well, this is relevant. To form an opinion as to whether an industrial dispute exists or is apprehended, as urged by Mr. Shanti. The formation of opinion as to whether an industrial dispute exists or is apprehended is not the same thing as to adjudicate the dispute itself on its merits. Here, my Lord, kindly have a look to the refusal order. My Lord, central government has decided the dispute, adjudicated the dispute. That is at page 26.
Kindly complete reading para 11.
Okay. In the instant case, as already stated, the dispute is as to whether the convoy drivers are employers of or workmen of Telco. That is to say, whether there is relationship of employer-employee between Telco and the convoy drivers. In considering the question whether a reference should be made or not, the Deputy Labour Commissioner and/or the government have held that the convoy drivers are not workmen, and accordingly no reference can be made. Thus, the dispute has been decided by the government, which is undoubtedly not permissible. Now, my Lord, kindly have a look to the, my Lord, refusal order, which is under challenge. That is at page 26. Well, towards the bottom. Sri Shekhar Mangla, the dependent son of late Satilal Maji, is not entitled for compassionate employment under the provisions of NCWA, as the provisions are applicable to those who expire or permanently disabled during the service period, whereas his father expired in the year 2016, who was dismissed by the company in 2010. So, my Lord, the petitioner has challenged the dismissal order also, my Lord, stating therein that at no point of time, my Lord, the dismissal order was served upon the deceased employee. So, my Lord, central government has decided.
Why didn't the deceased employee challenge it at the relevant point of time?
My Lord,
Certainly, after dismissal, he might not be working.
Might not be working, but he was not aware that he has been dismissed. My Lord, that has
He's not working, and he's also not aware that he has been dismissed.
My Lord, kindly have a look to the comments of the workman at page. All these are, my Lord, matters of evidence. All these are matters of evidence.
Where is it?
Yes, that is at page 23. That is rejoinder in reply to the comments of the management dated 4th of June 2018. That in reply to the statement of the management, it is submitted that like Satilal Maji was absent from due to unavoidable reason, and then same was duly communicated to the management. My Lord, case of the petitioner is that the unauthorized absence reason was, my Lord, communicated. Duly communicated to the management with a prayer to leave, but the management never replied to the prayer by rejecting the leave. It is pertinent to mention that no alleged dismissal letter ever received by late Satilal Maji. My lord, all these are matters of, my lord, evidence. How central government can decide? Central government has adjudicated the dispute. These are my submissions. And refusal
Can
is,
the union raise a dispute on behalf of a dead
Yes.
person?
yes, my lord, because but then in every case, my lord, dependent employment. The concerned employee is no more in service, he is dead. In every case of dependent employment, my lord,
The
no
concerned
third person,
employee is dead, but a person who is dismissed and thereafter he dies. There are two distinct situations
My lord,
altogether.
all these are matters of, my lord, evidence. My lord, the union will, my lord, lead evidence that at no point of time the concerned workman was communicated his dismissal order. All these are matters of evidence, my lord.
Union is raising the dispute
Yes,
regarding
union will prove, management will show whether that order was communicated or not.
Other judgment, should I place it? I have already given it yesterday.
There is one more judgment.
Yes.
2003. Secretary,
2003, yes.
Indian Tea Association.
Indian Tea Association, para 7, 10 and 11.
Madam, all these judgments of Honorable Supreme Court said, my lord, central government has power to, my lord, form an opinion, not to adjudicate. And here, my lord, in this case, refusal order, my lord, doesn't show that, my lord, it was.
Which paragraph are you referring?
Because paragraph 7, verses 7, subpara 1. May I read out your chips?
Yes.
The law on the point may briefly be summarized as follows. The appropriate government would not be justified in making a reference under section 10 of the Act without satisfying itself on the facts and circumstances brought to its notice that an industrial dispute exists and is apprehended, and if such reference is made, it would be desirable whenever possible for the government to indicate the nature of dispute in the order of reference. Now, if your lordship sees paragraph 10. Before making a reference under section 10 of the Act, the appropriate government has to form an opinion whether the employee is a workman, and thereafter has to consider it whether an industrial dispute exists or is apprehended.
Yes, ma'am.
In the present case, we find that state government rightly approached the question whether respondent number 1 was a workman. Unless this condition is satisfied, no reference can be made. Here the workman had already died.
And my lord, yesterday I made my submission, my lord. NCW is a settlement within the meaning of section 2P of the Industrial Disputes Act. It's a tripartite settlement between the management representative, workman representative, and Ministry of Labour representative. Show, my lord, the union has raised the dispute. Union is a party to the agreement. For enforcement of the right approved
And in 2012 judgment, your lordship, the delay was about 4 years. But the
my lord, here, my lord, the refusal is not on the ground of the adjudication of the dispute. That is my case.
Okay, WPL number 5260 of 2019. Heard the learned counsel appearing on behalf of the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner, while assailing the impugned order dated 5/3/2019, whereby the government has refused to refer the dispute for adjudication, has submitted that the dispute was raised not only in connection with the dismissal of the ex-employee, the father of the petitioner, who was dismissed from service in 2010.
Petitioner is union.
the alien is raising on behalf of the son of the deceased.
Sorry, please take it down. Has challenged the learned counsel for the petitioner. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner union has raised a dispute in connection with the alleged illegal and arbitrary dismissal of Santilal Manjhi.
May I submit on judgment of Honorable Supreme Court, Madam, Union can raise the dispute.
आपको इतना देर से सुन रहे हैं तो क्यों नहीं बताते?
The Union can raise the dispute.
Just show me that union can raise the dispute.
That is the year 1966 Supreme Court, page 182. Paragraph 1, my lord, may I read it, my lord?
Yes, please.
The short question of law which arises for our decision
Yes.
in this appeal is whether the order passed by Delhi administration referring the dispute between the appellants, the workmen of Messrs. Dharampal Premchand, Shogandhi, and the respondent, the employer, Messrs. Dharampal Premchand, Shogandhi, Delhi, was valid. The order of reference has been passed by Delhi administration under section 10(1)(d) and 12(5) of the Industrial Disputes Act 1947. When the Industrial Tribunal, Delhi, took up this matter for hearing, the respondent, my lord, this is the employer, raised a preliminary objection that the reference was invalid in as much as the dispute referred to the tribunal by the impugned order of reference is not an industrial dispute but is merely an individual dispute which cannot be the subject matter of a valid reference under section 10(1) of the Act. This contention has been upheld by the tribunal. My lord, rejected the reference with the result that the tribunal has held that it has no jurisdiction to adjudicate upon the merits of the dispute referred to it. It is against this order that the appellants have come to this court by special leave. On behalf of the appellants, Mr. Sukumar Ghosh contends that the view taken by the tribunal is not sound and that raises the question as to whether the dispute referred to the tribunal for its adjudication in the case can be said to be an industrial dispute within the meaning of section 2K of the Act. Thereafter, my lord, relevant portion is paragraph 12. It is well known that in dealing with industrial disputes, industrial adjudication is generally reluctant to lay down any hard and fast rule or adopt any test of general or universal application. The approach of industrial adjudication in dealing with industrial disputes has necessarily to be pragmatic, and the tests which it applies and the considerations on which it relies would vary from case to case and would not admit of any rigid or inflexible formula. There is no doubt that the limitations introduced by the decisions of this court in interpreting the effect of the definition prescribed by section 2K of the Act were based on such pragmatic considerations. It may also be considered that if the dismissal of an individual employee working in an establishment in Delhi is taken up by the Union of Workmen in a place away from Delhi, that would clearly not make the dispute an industrial dispute. Thereafter, my lord, relevant. Section 36 of the Act, which deals with the representation of the parties, incidentally suggests that the union which can raise an individual dispute as to dismissal validly should be a union of the same industry. Generally, it is the union of workmen working in the same establishment which has passed the impugned order of dismissal. But in a given case, it is conceivable that the workmen of an establishment have no union of their own, and some or all of them join the union to another establishment belonging to the same industry. In such a case, if the said union takes up the cause of the workmen working in an establishment which has no union of its own, it would be unreasonable to hold that the dispute does not become an industrial dispute, because the union which has sponsored it is not the union exclusively of the workmen working in the establishment concerned. In every case where industrial adjudication has to decide whether a reference in regard to dismissal of an industrial employee is validly made or not, it would always be necessary to inquire whether the union which has sponsored the case has fairly claimed a representative character in such a way that its support to the cause would make the dispute an industrial dispute. Industry has been defined in section 2J of the Act, and it seems to us that in some cases, the union of workmen working in one industry may be competent to raise a dispute about the wrongful dismissal of an employee engaged in an establishment belonging to the same industry, where workmen in such an establishment have no union of their own, and an appreciable number of such workmen had joined such other union before their dismissal. In fact, the object of trade union movement is to encourage the formation of larger and bigger on healthy and proper trade union lines, and this object would be frustrated if industrial adjudication were to adopt the rigid rule that before any dispute about wrongful dismissal can be validly referred to under Section 10(1) of the Act. It should receive the support of the union consistently exclusively of the workmen. Thereafter, this is relevant. Besides, there is another way in which this question can be considered. If 18 workmen thereafter the facts of the case has been narrated, dismissed by an order passed on the same day, it would be unreasonable to hold that they themselves do not form a group of workmen which would be justified in supporting the cause of one another. In dealing with this question, we ought not to forget the basic theory on which limitation has been introduced by this court on the denotation of the words industrial dispute as defined by Section 2K of the Act. Therefore, my lord, the tribunal's orders were set aside.
So I have never submitted that union cannot raise. I said that after the death of the workman, there is no relationship.
You see, the point is, if a person has expired, can the union raise a dispute in representative capacity of a dead person?
In all cases of my lord dependent employment, the concerned workman is no more in this world. So on his behalf, some person will my lord raise a dispute.
No,
Here, my lord, union has raised the dispute.
no. It is a case where, when there is a case of dependent employment flowing out of the NCW. But here is a case where the workman has been dismissed, his relationship as employer and employee has ceased, and during his lifetime he never raised a dispute.
But that
Then can the son raise such a dispute, question the order of dismissal passed 4 or 5 years, 6 years, 6 years prior to his death, and then claim compassionate appointment?
Well, his dismissal order is also on the challenge. That is very.
So show me one judgment which says that नहीं मिलेगा ना?
ऐसा direct नहीं मिलेगा. But here, my lord, the central government has adjudicated the dispute. That is my.
No, they have not adjudicated the dispute. They say that who expired, whereas his father expired in the year 2016 and was dismissed from the company in 2010.
So, my lord, these things, my lord, whether the dismissal order was served upon the concerned employee or not, all these are matters of evidence.
दीजिए तो जरा इंडस्ट्रियल डिस्प्यूट्स एक्ट. The definition of workman under the Industrial Disputes Act specifically includes dismissed employee. But it does not include an employee who has deceased after dismissal. Just see. The definition of workman दीजिए भाई, उनको भी idea है. आपको पता है? पढ़िए जरा workman का definition.
Industrial disputes mean any dispute or difference between employer, workman, which is connected with the employment or non-employment or terms of employment or conditions of any person.
Workman का definition.
Yes.
Section 2S.
But means any person, including an apprentice employed in any industry, to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory, whether the terms of employment be expressed and for the purposes of any proceeding under this act in relation to includes any such person who has been dismissed, discharged, retained. Yes, my lord, that is there.
So, a person who is dismissed and deceased, can an industrial dispute be covered for such person? Is the question. Dismissed and deceased.
If, my lord, the dismissal is, my lord, bad. My lord, tribunal can adjudicate the same. If the matter is referred to the tribunal, tribunal can adjudicate the same whether dismissal was right or wrong.
सब रिसर्च वर्क मेरे ही लिए छोड़ देते हैं. Heard the learned counsel for the parties. It is not in dispute that the learned counsel for the petitioner, while challenging the impugned order as contained in Annexure 5, has submitted that the industrial dispute was raised by the union, who is the petitioner before this court, challenging the order of dismissal of the ex-employee, namely Santilal Manjhi, who was dismissed in the year 2010 and expired in the year 2016, and consequently had also raised the dispute regarding denial of dependent employment by the management of the respondent. The learned counsel submits that the respondent has the central government has exceeded the jurisdiction by adjudicating the dispute, and therefore the impugned order calls for interference. The learned counsel has relied upon the judgments passed by the Honorable Supreme Court in the case of judgment.
1989 3
In the case reported in the case of Telco Convoy Drivers Mazdoor Sangh and another versus State of Bihar, reported in bracket 1989 bracket close 3 SCC 271 para 11 and 13, and also orders passed by this court in the judgment reported in 2010 within bracket 4 JLJR 693. One should be sufficient, wherein the aforesaid judgment passed by the Honorable Supreme Court has been followed. Ek judgment?
It's Sarkar Shramik Law,
The
2009 volume 11.
2009-11.
2009 volume 11 page 609.
ये कहा, ये तो नहीं दिया. 9-11 तो नहीं दिया. 10, 15, 9-11 नहीं दिया. ये एक ही का 2 कॉपी दे दिया, वो आप हमको दे दीजिए. 2000 ये लिखिएगा. Followed by this court, reported in 2009 volume 11
SCC page 609.
609. अच्छा ये sorry, and also a judgment passed by the Honorable Supreme Court reported in bracket 2009 bracket close 11 SCC 609.
2015 2 JLJR.
2015 volume 2 JLJR
page 95 Jharkhand.
page 95 Jharkhand. The learned counsel appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that the impugned order does not call for any interference. The claim is a stale claim. The deceased employee, the ex-employee was dismissed in the year 2010 and expired in 2016. And the son of the ex-employee and the union raised the dispute at the instance of the son of the ex-employee who claimed compassionate appointment after death of his father. The Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2015 bracket close 15 SCC para 12 and 42 and judgment reported in bracket 2000 bracket close 3 SCC 93 para 7 within bracket 1 bracket close 10 and 11. And I submitted that the claim is a stale claim. He has also submitted that no industrial dispute exists or is apprehended. यही है आपका?
Yes. The reason that the employee never challenged it and
For the reason that the ex-employee never challenged his order of dismissal for 6 years and after his death the cause of action does not revive. Okay? कल लिखेंगे. Arguments concluded. Post for further dictation tomorrow. खोजते हैं कुछ मिलेगा. अब कल बहस मत करिए.
नहीं कुछ मिलेगा तो दे सकते. My junior said that I cannot search any judgment because court said that tomorrow I will not accept any judgment. Therefore I also did not do any research.
भाई ये रिसर्च पहले से कर. ये कोई नया चीज तो नहीं है.
Actually, Lordship, I allow.
Judgments must have come to this effect.
There are several judgments in the High Court also where some cases the court has interfered, some cases court has not interfered.
No, it is not a matter of interference with the point of reference, but the point is where a person has already been dismissed, and thereafter he dies.
Yes.
And that order of dismissal was never challenged during his lifetime.
Yes. Actually, she told me she was doing this because I did
कर
not.
लिया research, मिला?
नहीं, ये हमको बोला कि कल आपको कोई नया जजमेंट देने का मौका नहीं मिलेगा. नहीं सर, देने तो
ये तो कोर्ट बोलते ही रहेगा. तो important point पे तो push करना ही है ना. If it is important for the judgment, then it has to be considered.
Because even if there is any judgment against me also, I should be fair enough to show it. Therefore,
खोजते हैं. दिखाएंगे 4 बजे लेकिन उसके पहले नहीं. 4 o'clock के पहले.
Yes, sir, that would be better.
Yes.
While submitting in the morning, I would mention slip 1 in respect of serial number 40. Actually speaking, I have inadvertently written in the mention slip the analogous cases has been listed on 12th April, but actually speaking, I have seen from the status that it is not 12 but it is 15th April.
स्लिप इनको वापस कर दीजिए. पोस्ट कर दिए क्या?
वो 15 अप्रैल कर दिया.
अब जो एक बार हो चुका है उसके बाद आप 12 तारीख को पूछ
नहीं
सकते.
तो ये स्टेटस हमको हम नोट किए थे 12 लेकिन एक्चुअली 15
तो कोई बात नहीं, आने दीजिए. हम लोग इससे बार नहीं कर सकते. ये चीज आपको केयरफुली होके मेंशन करना चाहिए.
उसमें हमारा स्टेटस स्लिप नहीं था मेरे पास.
Yes.
Serial number 24 not to be taken today. The council is out of town. Serial 24.
Who has asked you to mention at the time of rising at 1:35? Who is your senior who has asked to mention at this hour? You have to go home?
No.
You don't enjoy the court? Very boring court. This is not the right time to mention in any case. For adjournment also you will have to wait. Otherwise we put a date. Automatically every case has a date and we take up the matter slowly. These matters are contested matters.